This chapter introduces the student to the American court system. There are 12 learning objectives. This introductory video and section will only cover the first 4. Identify the type of court structure in the United States and describe its various components. Summarize the purposes of courts. Identify the most powerful actors in the administration of justice. And explain what makes them so powerful. Summarize the types of attorneys available to a person charged with a crime. The United States has a dual court system, a separate judicial system for each of the states, and a separate federal system. The authority for the federal court system is given in Article 3, Section 1 of the United States Constitution. The federal court system includes the Supreme Court, the federal courts of appeals, and the federal district courts. United States district courts form the base of the federal court structure. These are courts of original jurisdiction, or courts where most violations of federal criminal and civil law are first adjudicated. There are 94 district courts, with at least one in each state. Kentucky has 2 districts. The United States District Court of Paducah is in the Western District. A person or group that loses a case in district court may appeal to a federal circuit court of appeals, or in some instances, directly to the Supreme Court. Congress created the United States Circuit Courts of Appeals in 1891 to reduce the case burden of the Supreme Court. These courts have only appellate jurisdiction and review a case for errors of law, not of fact. There are 13 United States Circuit Courts of Appeals. The 6th Circuit Court of Appeals, located in Cincinnati, hears appeals from the United States District Court in Paducah. The United States Supreme Court is the court of last resort in all questions of federal law. For a case to be heard by the Supreme Court, at least 4 of the 9 justices must vote to hear the case. The Rule of 4. When the required number of votes has been achieved, the court issues a writ of certiorari to the lower court whose decision is being appealed, ordering it to send the records of the case forward for review. In certain circumstances, an imprisoned defendant whose appeal has been denied may still try to have the Supreme Court review his or her case on constitutional grounds by filing a writ of habeas corpus. The laws of each state determine the organization, function, and even the names of its courts. It is useful to distinguish 4 levels of state courts: trial courts of limited jurisdiction, trial courts of general jurisdiction, intermediate appellate courts, and state courts of last resort. These lower courts typically deal with minor cases such as ordinance and traffic violations, some misdemeanors, and, in many jurisdictions, civil cases involving less than $1,000. In many states, they are allowed to conduct summary or bench trials or trials without a jury. A Kentucky example is juvenile court. Its jurisdiction is limited to cases involving juveniles, and there is no right to a jury. The lower courts in most states also hear the formal charges against persons accused of felonies, set bail, appoint counsel for indigent defendants, and conduct preliminary hearings for crimes that must be adjudicated at a higher level. In Kentucky, the lower courts are called district courts. Depending on the case, they have both limited and general jurisdiction. For example, a Kentucky district court may have limited jurisdiction over juvenile cases on a Wednesday and have general jurisdiction over misdemeanor cases on Tuesday and Thursday. It may also hold preliminary hearings on these days, but at different times, depending on the court docket. Depending on the state, trial courts of general jurisdiction may be called district courts, superior courts, and circuit courts, depending on the jurisdiction. In Kentucky, circuit courts have general jurisdiction. Trial courts of general jurisdiction have the authority to try all civil and criminal cases and to hear appeals from lower courts. They are courts of record. Circuit courts are also courts with original jurisdiction, since they have the authority to hear a case for the first time. Specialty courts augment trial courts of general jurisdiction. These have been created during the past 3 decades to deal with increases in certain types of crimes or chronic social problems. Drug courts were the first of these new problem-solving courts, the first of which was established in Dade County, Miami, Florida, in 1989. Kentucky has drug courts and other specialty courts, such as family or domestic violence courts. In some of the geographically smaller and less populous states, there is only one appellate court, the state court of last resort, usually called the state Supreme Court. Many states, however, have created intermediate appellate courts to reduce the overwhelming case burden of the state Supreme Court. These courts have no trial jurisdiction. They hear only appeals from trial courts of general jurisdiction and are charged with reviewing cases for errors of law and ensuring that legal procedures were followed. In most states, the state court of last resort is referred to as the state Supreme Court. The primary responsibility of state courts of last resort is to hear appeals from either trial courts of general jurisdiction or intermediate appellate courts. Your text lists several purposes of our American courts: to do justice and to appear to do justice. Due process of law refers to the procedures followed by courts to ensure that a defendant's constitutional rights are not violated. To provide a forum where disputes between people can be resolved justly and peacefully. To censure wrongdoing. Incapacitation, removal or restriction of the freedom of those found to have violated criminal laws. Punishment, imposition of a penalty for criminal wrongdoing. Rehabilitation, the attempt to correct the personality and behavior of convicted offenders through educational, vocational, or therapeutic treatment and to return them to society as law-abiding citizens. General deterrence, the attempt to prevent people in general from engaging in crime by punishing specific individuals and making examples of them. To determine legal status, to protect individual citizens from arbitrary government action. The three central figures in the court system are the prosecutor, the defense attorney, and the judge. The prosecutor. As the chief law enforcement official in a community, the prosecutor holds significant power in the justice system, including deciding whether to charge, prosecute, or dismiss a case, nolle prosequi. Charges are brought only when a crime is confirmed, the suspect is identified, and evidence supports a conviction. Most convictions, around 95% of felonies, result from plea bargains, where the prosecutor plays a leading role. Prosecutors also recommend bail and must share exculpatory evidence with the defense under discovery rules. Often elected through partisan processes, few prosecutors remain in the role long-term. Many use it as a stepping stone. Assistant district attorneys, typically recent law school graduates, carry out much of the prosecutorial work. Defense lawyers ensure that defendants' rights are protected and offer legal representation at all critical stages of the process, including interrogation and trial. Their job is not to judge guilt, but to secure the best possible outcome, often through plea deals. Indigent defendants may be represented by court-appointed attorneys, public defenders, or contract lawyers. Public defenders are salaried and frequently rotate across courtrooms, while contract lawyers serve jurisdictions under a fixed-fee agreement. Indigent defense systems are moving toward greater state oversight and funding. Judges oversee both trial and pretrial proceedings, ensuring fairness and due process. They preside over jury trials and rulings on evidence and bail. U.S. judges are predominantly white, male, and older, with backgrounds in private practice. They are selected mainly through elections or merit-based systems. While lower court judges may not require legal credentials, appellate and general jurisdiction judges must be licensed attorneys, with many states mandating judicial training. Professor Reese notes that although the video is lengthy, it's important to watch and study it thoroughly. Grasping the court system will be useful for future topics.